So we went over motions you can file prior to your answer if you want to contest jurisdiction or file a motion to dismiss. Now, along with your answer, you can file a counterclaim. So if there's a petition for custody and support that you're served with, you can file an answer, and you can also file a counterclaim if you yourself are wanting to establish custody or some sort of custodial schedule. Okay? Biggest thing is you're served with paperwork, do not ignore the paperwork. If you don't answer in the time that you're given to answer, you can get what's called a default judgment against you, which means that your spouse, your wife, will get awarded to her, most likely, everything she asked for in her petition. All right? So do not ignore these things. Now, when you're drafting your pleadings, whether it be your complaint or your answer, your counterclaim, you want to keep this in mind because this is what your trial will consist of when you're in a custody case. Now, the best interest of the child standard, that is the prevalent standard that's used in family court. There's a lot of frustration that we have with that standard because there is no definition of what it is. It's just a set of factors. Some of these factors are listed here. They look at the mental and physical health of the parents, which parent will facilitate a relationship with the other parent, abuse or neglect issues, special needs of a child, the age and gender of the child, which is, I take huge issue with that, because just because you're a man doesn't mean you can't raise a 2-year-old little girl, vice versa, just because you're a woman doesn't mean you can't raise a 3-year-old little boy. All right? So I think there's some huge constitutional issues with the court considering age and gender, but nonetheless, it's still in the books. Which parent is able to care for the children financially, socially, right? And I don't even know why that's in there either, because there's a lot of parents who don't have the financial means to raise children, and so the courts tend to supplement that with child support and alimony, right? The wishes of the child, right? That's a factor. That's also very problematic because alienation can come into play if a parent knows that the court is going to consider the wishes of the child. They look at who was the primary caretaker of the child during the marriage. They look at the relationship that the child has with the parent prior to the separation and the geographical location of the parents. So these are all things that the court will look at when they apply this best interest standard. All right, so I want you to look at this as an answer and a counterclaim. So what we have here is you have where it says answer, okay? Now, we saw in the complaint where it said that the father is over the age of 19 years. He's been a resident citizen of Montgomery, Alabama for more than 6 months next preceding the filing of this petition. If that's true, all you have to do is paragraph 1, admit. You just admit that paragraph, right? Same thing with paragraph 2. Husband avers that the wife is over the age of 19 years of age, is a resident citizen of Montgomery County, Alabama, has been so for more than 6 months next preceding the filing of this complaint. Admitted. Easy. Okay? So the court knows I don't have to deal with any jurisdictional issues. I have jurisdiction over that. Number 3, you might say the parties were married on March 1st, 2010, right, in Clarksville, Tennessee. Admitted. All right. So now the judge knows they're both of age, they meet their residency requirements, and there's a valid marriage. Okay? Now, there might be something you don't really admit. So this, in number 4, it says partially admitted. Husband admits any information related to the child born to the marriage and denies the wife is the parent who should have the sole custody. So lawyers will do this sometimes. They'll say that the parties had one child, Elizabeth Smith, who is 2 years of age, and the wife further avers that she should have the sole legal and physical custody of this child. Well, part of that is true. Part of that is not. You don't want to admit that paragraph because you're not going to admit that she should have the legal custody. So you can partially admit. Say, I partially admit, I agree that we have this child who is this age, but I deny the remainder of the paragraph regarding custody. Okay? Next one, partially admitted. Husband avers that child support should be calculated in accordance with the split custody calculation. All right? So in this case, what the mother said was she wishes the court would award child support, right, and give more child support than what the court asks for because she doesn't make enough money to support herself and support the child. Okay? So we admit we want the court to apply the child support calculations. We're not saying to us. We're just saying, yeah, we admit that you should apply the child support calculation, But what we say is it should be calculated in accordance with the split custody calculation. Okay? So watch your paragraphs before you admit something, because if you only agree with half the paragraph, don't admit the whole paragraph. Okay? Make it known to the court what you admit and what you disagree with. Okay? And if something is admitted, you just admit it. Like this one, paragraph 8, just says denied. Right? She might say that the wife avers that she suffered abuse at the hands of the husband for the duration of the marriage. Denied. Okay? Remember, you don't try your case in these initial pleadings. This is just letting the court know what's at issue, what does the court need to look at. Okay? Now you can go to the other side. Now you get into your counterclaim. All right? Now in your counterclaim, you can lay out the same jurisdictional grounds, age, residency, things of that nature. And this is where you tell the court what you want, okay? Here, we want a shared custody situation. We identify who the child is. It's important to say, too, that the wife is not currently pregnant, or based upon the information belief of the husband, the wife isn't currently pregnant, right? Because we've had several cases where the wife was pregnant when the divorces were filed. Sometimes it was his, sometimes it's not his. But if she is pregnant and you don't know, right, and if the child is born while you're still married, even if you're going through divorce, if the divorce is not entered yet, if you're still married and that child is born, you are the legal father, okay? So it's always important to throw that in there. Hey, based upon information belief, we don't know her to be pregnant right now, okay? So again, your counterclaim kind of mirrors the petition. You ask for the same relief in there. Okay. Now, after the pleadings, you get your discovery, you start prepping for court. Witnesses are so important. So many times people will go to court and they'll say, "Oh, I'm ready. I got 10 affidavits from 10 different people." That is called hearsay. Okay? Your witnesses have to be in court, sworn in, and be subject to cross-examination. Right? So if you have, say, I got a affidavit from her ex-husband, and he said she's a liar, he said she's a cheat, he knows she did drugs when my child was in the house, that affidavit's not coming in, it's hearsay. Okay? Hearsay is an out-of-court statement made in court for the truth of the matter asserted. So if you're introducing that affidavit to show the court that she lies, that she's doing drugs around your child, if you're introducing it to show that what this guy says is true, he has to be in the courtroom subject to cross-examination. Okay? It's a big issue, is people think, or somebody says, "Hey, I'll testify for you. I'll testify." Okay, you get that a lot. I'll be there for you. And then when a push comes to shove and you want them to be there, "Well, can I just write an affidavit instead?" So many clients will call and they'll say, "Well, I know that, her mom was going to come and testify for us, but can she just write an affidavit instead?" No, she's got to be there. You've got to be there. Now, if you have someone who's going to testify for you, if you're in a state that allows recording, record your conversation with that person. Right? I've had several mother-in-laws who say, "You know what, I'm going to come testify for you." So I'll call them, and they'll tell me everything. "Oh, yeah, she's horrible. She lies. She steals money. She does this. She does this." What happens when their feet hit the courthouse steps after they get a subpoena? "Yeah, I just can't. I can't." They get up on the stand. "Does she have a history of stealing?" I can't really recall." "Well, ma'am, do you recall our conversation that we had about 8 weeks ago?" No. "If I play the recording, will it refresh your recollection?" Right? Witnesses will flip on you in a heartbeat. Now, or if you have somebody who says, "I'll come testify for you," if you're in a two-party state where you can't record the conversation, okay, get an email string started. See if they will sign an affidavit, but get email stream started. "Hey, Miss Smith, thank you so much. I know that you care about my kids, just as much as I do. And I can't believe, you told me that she was arrested for stealing, for drugs, whatever. Thank you so much. And I really thank you for coming forward with the truth." She responds back, "Anytime, I'll do anything for my grandkids, whatever." Bring those to court, because witnesses will flip on you. Now, the question was, if it's a different characterization of testimony, if someone's coming to court to say something good about you, do they still have to be there? Anytime that you want their statement to be taken as true, they have to be there subject to cross-examination. Okay? Because let's say that you bring in somebody who says, oh, he's a great guy. He has a reputation for being honest. He has a reputation for truthfulness. And they just go, well, what a great guy you are. So I stand up and I say, well, how long have you known Mr. Smith? Gosh, I've known him for, I guess, about 2.5 years. We worked together daily for about 2.5 years. Oh, so you weren't aware that 3 years ago he was caught shoplifting at such and such place? No, I didn't know that. And you didn't know that he pled guilty to shoplifting, did you? No, I didn't know that. So the other attorney has to have the opportunity to try to impeach what you're saying, okay? So anytime anybody is in court making a statement that they want the court to take as true, they have to be subject to cross-examination. Otherwise, it's hearsay, okay? You want witnesses who can testify to your relationship with your child, because that's one of our best interest factors, okay? So you can bring coworkers in, say, oh yeah, every day he leaves at 2:45, comes back at 3 o'clock, child sits in his office for the remainder of the day, they do homework together. Great relationship. I see the little girl, she's hanging on her daddy, she volunteers how much she loves her daddy. Right? You could bring in teachers, neighbors, family members, friends, okay? So people who have firsthand knowledge of your relationship with your child. Witnesses who can testify to your ability to care for your child. Okay, neighbors might come in that respect. Neighbors say, I see little boy on his bike out front. He fell off. Daddy was right out there, picked him up, cleaned his knee up, put a Band-Aid on it, talked him through it. And within 10 minutes, that little boy was back on his bike, and Daddy was right beside him, running, cheering him on. Okay. I see Dad outside. He's grilling with the kids. He's the one that makes supper. I don't see Mom's car pull in the driveway till 9 o'clock at night, 6 o'clock, she's gone the next morning. Well, if that happens, who's taking care of the kid? Dad is, right? Now, coworkers are good because your schedule might come into play. Well, I can't share custody with him. He just doesn't have time with his schedule. Okay, shift workers, okay, EMS workers. You guys, this is a huge problem. Huge problem. Well, we can't share custody. He works 48 on, 48 off. Okay, so how about the 48 hours he's with you, when your ex is at work, your husband's at work, be with you. When your husband's off, he'll have the kids. Yeah, but he gets called in overtime. That's just not going to work. They're not flexible at work at all. All right, so maybe bring in his boss to say, no, we're very flexible, actually. He has 510 hours of leave, and he can take this leave to go to pick up the kids. We're very flexible. We're very friendly to divorced parents. So bring coworkers in, bring supervisors in who can testify that you do have a job that's very flexible, because there's a stigma and a stereotype attached to people who work shift work that they're somehow not able to share custody because of their schedules. So it's important. Bring in coworkers, bring in supervisors who can refute that. Believe it or not, former girlfriends and former spouses, they can make really good witnesses. They were there. I have a lot of clients who they get along great with their first wife, and second wife is just a train wreck. First wife can come in and say, first wife, second wife testified earlier that he's extremely difficult to get along with, that he's short-tempered, that he doesn't help around the house. First wife says, but that's not been my experience. Actually, we've been sharing custody of our child for the last 7 years. It's been going great. When we were married, he didn't have a short temper. Every once in a while, former wives and ex-girlfriends will step up and they will testify on your behalf. If you have somebody that you're in a relationship with, that you're on good terms with, see if they'll testify for you. And sometimes they lived in the house, so they can act. They have first-hand knowledge of observing you parent your kids. Yeah. It was a question, I guess, and a comment where you weren't sure about bringing teachers in because generally teachers don't want to be put in the middle. And whose fault is it that the child may not be doing well in school? Okay. So, teachers, I find teachers to be more helpful, and the ones that are hurtful, we just don't send subpoenas to them. Okay? Now, this is where you guys get in trouble. You don't get involved in the schools. You could be an excellent dad. I say, what's your child's teacher's name? She's got blonde hair. No, what's her name? Like Sandra, Sandy, Sally, Samantha. Starts with an S. You do that on the stand, judge might be like, well, obviously he's not as involved as maybe he says he is. He doesn't even know his teachers' names. No, be involved in the school. When you drop your kid off, go in, talk to the teacher. Hey, look, if anything comes up, let me know. A lot of schools now have like online access where you can log in, you can see their grades, and it's probably because of there's so many divorced parents, but be really involved in their school. So a lot of times, if you get something from the wife that says, in this case I was talking about earlier, she says, our child's doing horrible. Teacher says he's special needs special classes. She said they had to call the ambulance because he was about died having this asthma attack. Okay, called the teachers. The teachers say, I really don't want to get involved, and say, I understand that, but tell me, when you said he's a special needs child, well, I never said that. Oh, because she told him you said he needs special education. I never said that. Okay. Well, tell me, when you called the ambulance, is there a reason why you didn't call my client? I never called the ambulance. Well, she said you did. I never called the ambulance. And by the end of that conversation, that teacher was like, yeah, send the subpoena. Yeah, can somebody bring it over to me? Because I'm going to be there. I'm going to be there. Now, even teachers, if the teacher says, look, I don't want to get involved, I think they're both good parents, that's good testimony, isn't it? If the teacher comes in and says, like, I'm not even sure why I'm here. I don't have a problem with Dad, and I don't have a problem with Mom. I'm not even sure why I'm here. That's still good for us, by the way. Because Mom will say, I don't think that he can get the child to school on time because of the schedule. He's just not really personable, so I just don't think he'll do really good with the teachers, and plants that doubt. Teacher's sitting there, I don't even know why I'm here because this child does fine when they're with both parents. I don't really know. So when Sally comes to school when he's with Dad, she's with Dad, is she dressed good? Yeah, she's clean. Dad does a good ponytail. Yeah. Child come to school when it's clean. She's clean. She's presentable. She's happy with Mom. Yeah, same thing. Honestly, I really can't tell the difference. That's good for us. It's good testimony. So the teachers who want to stay out generally will testify neutrally when they get on the stand. Again, it's good for us. But, sometimes there's personality conflicts. You might not always want to subpoena the teacher. But as a general rule, we've had pretty good luck with teachers. But dads, stay involved. Make sure the teacher sees you, okay? Make sure it sees you. We joke because, my kids are they're 4 and 6. I have a first grader. And there's a chat with all the moms in the chat. I'm not in the chat, my husband's in the chat. So my husband's in the chat with all the moms. So we laugh about that. But at the same time, that's because the moms are the ones that usually are up at the school. Not because dads don't care, by the way. It's not because you don't care. But I sort of prescribe to, well, if there's an issue, they'll let me know. She comes home, she does her homework. I don't feel the need to go ask the teacher, well, how's she doing in school? I can see it. Okay, my husband's more involved in that. He's in the mom chat, and it works out well for us. Okay, and relationships are different. Okay, he's back there in the blue shirt. He's in the mom chat. He takes the kids to school. He picks them up. He's more involved. But that's our dynamic. If something were to happen and we were to divorce, at that point, I would be more involved because I'm not getting the information from my husband anymore. Does it mean I'm a bad mom, that I'm not as involved as he is? No, it doesn't mean that at all. Not at all. That's the dynamic. That's what works for our relationship. But understand, when there's a separation, that dynamic has now changed. You have to change as well. Because if you don't, it could be used against you in the courtroom. Okay? All right, again, neighbors, family, and friends, of course. And everybody likes to bring their mom in. Moms are great, okay? But the judges know your mom's going to testify. Little Jimmy's great, and he's a great daddy. And okay, usually they ask me, do you have any questions? I don't have any questions for her mom. Yeah, I'm good. So really, if you can go outside the bloodline, that's where you bring in the better witnesses. But of course, family and friends are good too. All right, now exhibits. You want to make things as easy for the judge as you can. Okay? So if I'm going to testify, all right, Judge, since separation, I've had my child 65% of the time. I have them Mondays, Tuesdays, Wednesdays, and then I pick them up Sunday nights. Okay? I might want to put out an exhibit and say, and two, this is when I've had my child. Put all the dates out. This is the dad column, right? Here's all the dates. This is the mom column. I'm going to make it shorter. All right, I want to admit this exhibit for the judge, okay? This is a summary of my testimony. Judge can look at it and be like, okay. Doesn't have to calculate anything in his mind, okay? It's a sort of visual thing. Put your expenses out. Right? Dad's, he doesn't contribute. He doesn't pay enough. Okay? Well, let's look at your expenses. All right, well, I've got student loan debt, I've got a car payment, I've got car insurance, I've got this, I've got this, I've got this, and I have $300 left over at the end of the month for disposable income, and I spend about $350 on my child. Well, how could that be? Well, actually, there was my mom gave me $50. I added that in here. Every dime I spend goes to expenses and to my child, okay? Put it in front of the judge. So you have your pay stub showing how much you bring home, and you have your expenses, and you can attach your bills to that. My light bill's $250. Here's the bill. My cable bill is $89. Here's the bill. My cell phone bill is $100. Here's the bill. There's no guessing. You're not padding your expenses. It is what it is. Child care, especially if you have young children, is extremely expensive. Attach the bill. So whatever you should know, do discovery, what's going to be used against you, bring the ammunition in to show the judge, refute those things, okay? List of payments, receipts, copies of canceled checks are great, okay? He didn't pay this. Well, yes, I did, okay? So if your ex is saying, Judge, there's a bill for $200 that's been outstanding for 3 months, I keep telling him he won't pay it. You say, yes, I did, it's paid. Judge is like, I don't know, somebody pay the bill. Yes, I did, I paid it. Here's the canceled check. Done. End of story. And Judge, here's the bill zeroing out the balance after I paid it. Well, did you tell her you paid it? Yes, here's the email where I sent her these exact same documents 3 weeks ago. I know she's bringing it up now. Okay? Try to bring in all this evidence. Try to reinforce everything you say. All right, phone record exhibits. You take the phone record, highlight the boyfriend's phone number, highlight. Judge, the boyfriend is highlighted in yellow, and the husband's highlighted in orange. There's 2 calls in these 4 days, and there's 78 calls to the boyfriend. By the way, the child's with Dad. You calling the boyfriend to check up on your child? Oh, no. But you still call twice in 4 days. But let's look at the incoming calls from Dad to you, Mom, to let you talk to your child, okay? So great exhibits from a visual standpoint for the judge. Okay, if there's property on the table, bring in property lists. All right, we have Chevrolet pickup truck, we have a Camaro, we have a Jeep, we've got this house, we've got this, we've got this. These are the values. You can attach the tax records, and then you give a justification as to what you want. I want to keep this. Here's showing it was purchased before the marriage, whatever the case is. But lists are great. Make it easy for the judge as you can. Custodial periods, I think we already went over that. Here's a list of all the times the kids were with me. Here's a shorter list of when they were with Mom. Denials of requested contact, right? Judge attached to this exhibit, there's 50 pages of me asking her in text message, can I see my son? Can I please talk to my son? How did he do in school today? Please have him call me. There's 50 pages of one-way text messages, not one response. She's like, well, I don't really do texts. Okay, oh, let's move to the phone bill. These are phone calls to you. Well, he didn't leave a message. Here's the recordings of the voicemails that are left. Okay? Your case will be so much better if you say it and then you show it. You say it and then you show it. Okay? If something is said against you, you refute it and you show it.
Yeah, what's your topic?
Okay, so some judges have orders in place. Okay, I'm sorry, let me summarize your question. You're saying it's not always strategic to show your hand. So when do you give this stuff over? So if there's no discovery served upon you, if you're not asked to give this stuff, the first time they see it is in the courtroom. So when we file discovery, we ask for, I want to see your exhibits, right? Anything that you may rely on in court, anything that you intend to rely on in court, so different things. Because if you serve me with discovery, I might have a general idea, yeah, I'm probably going to use this, but if you ask me what I am going to use, you're not going to get it till close to the court date, because I don't know if I have to use it yet. I don't know. If you ask what I may rely on, all right, so if you have pictures of abuse, and they're in your possession, and you're alleging abuse, and I ask you what you may rely on, and you don't give me those pictures until the day before court, I might cause a stink. Say, wait a minute, Judge, she's had these pictures in her possession since before this was filed. I asked for them, and she emails them the night before court, and not even the real, I can't even make it out. It's all gritty, it's black and white. So you can go in there, you can kind of make a stink about that. And he said, well, Judge, I didn't decide I was going to use it till the night before. That's not what I asked you. I asked you what you may rely upon as well. Okay? So it depends on the discovery questions, and some judges will enter pretrial orders. All exhibits must be exchanged 14 days before trial. So 14 days before trial, you have to send everything over there. If you withhold something back, you risk the judge saying, well, it wasn't exchanged in accordance with my order. 14 days before trial, you can't use it. Okay? So it depends on discovery, and it depends on the orders of the judge. So the question was, we talked about earlier not responding, but you're saying that your response might be better to the judge versus the person who's asking.
Exactly.
Okay, doesn't work that way. Not the way it works. So if you want to tell the judge something, but I as the attorney send discovery to you and say, you have to give me this, you have to give it to me.
Right.
Okay. Now, but I think you're confusing the two. In the event of a default, if you're served with something, a complaint for divorce in custody, and you have 30 days to answer, and you don't answer, you just ignore it, okay? Then I can apply for a default judgment. I get a default, meaning the judge will most likely give me everything I asked for, and you now lost custody. I have possession of the marital home. You have to give me alimony, full child support. So that and discovery are really two separate issues. So you're saying there should be some sort of ethical guidelines regarding communication between you and your spouse through all this? If you get an email saying, hey, look, what are you fishing for? What are you going to come at us with court? I would just say, look, please respond to my discovery, and, we need to litigate this matter and move on. Okay? Don't get into conversations. What I tell my clients, if it doesn't have to do with your children, don't get in arguments, don't get in discussions. You have one thing to talk about, okay? And that's your kids. Now, if you get a text message and it's antagonistic, don't engage, but defend yourself. If you get a text message that says, you sorry SOB, I got the letter, or I got the documents from your lawyer today, you're abusive, you've always beat me, and I'm going to take you to the cleaners. Your response is, that is not true, and I'm not going to argue. Stop, and that's it. It's not true. If somebody came up to me and said, yeah, Melissa, I heard you kicked your grandma in the face, I'm not going to sit there silent. I'm going to say, no, I didn't. No, I didn't. There's some things that you just deny that aren't true. You beat me during the marriage. I did not beat you during the marriage. I did not beat you, and I'm not arguing with you. And leave it there. Don't engage. Engagement is power. Okay, one thing about women that I've found is proximity is power, and engagement is power. Okay? So there's been several times where husband comes in, he's distraught, he's emotional, just found out about the affair. And I tell him, okay, I want you to, and she's like, let's try to work this out. I caution him. She will probably say, look, we've been together for such a long time, it can't end this way. Let me come to your house and we'll have a discussion, okay? That man is vulnerable at that moment. This woman he still loves gets in his physical presence, okay? And there's a lot of touching. I wouldn't have done, I love you so much, I would never do anything to hurt you. All of a sudden, we get into the forgiveness under the law thing, right? There's a sexual act. So you have to be careful how you engage, especially when you're vulnerable. Don't argue, okay? What I tell my clients too, especially when they're emotionally vulnerable, they need time to process everything. She wants to come to your house, just say, listen, let's just email, let's just text. Don't come to my house right now. Because emotions rule the day right then and there, okay? Don't engage, especially when we're dealing with people who have narcissistic tendencies, borderline personality disorder. Engagement is power, right? And sometimes women will change tactics. They'll come and they'll say, I'm so sorry, that they beg and plead, right? Let's just drop all this. We'll make it better. If that doesn't work, then all of a sudden the threats come out, right? This didn't work over here, so we're going to change tactics. If you do this, you're not going to see your kids. If you do this, I'm going to make sure you lose your job, right? That doesn't work. Well, then let's switch to, I'm going to kill myself if we don't, get back together. Right? I don't want to take suicide lightly or the threats of it. But I'm saying I've seen these tactics change, where she will change to get that engagement, okay? So a lot of people with personality defects will do that because it's more about manipulation than it is about mending any sort of relationship. Okay? The best thing to do, especially if you're emotionally vulnerable, don't engage. Don't engage. If she sends you a message saying, hey, our child needs this medication, great, do you want me to pick it up, or do you want me to pay for my half, whatever the case is, okay? If she says, hey, at CVS, it's $12, you go pick it up, certainly will. And I'm just glad that you're picking it up now because you were a SOB during the marriage, didn't help out none at all, so I'm just glad you're finally stepping up to the plate. Don't even respond. That doesn't warrant a response, okay? Don't engage. So be very careful on what you engage because I can't tell you how many times, and I've had this conversation with my clients, and then I get text messages and they start out okay, and by the end, there are paragraphs back and forth that are just irrelevant that get read on the stand. So the best thing you can do, just don't engage. Yeah.
Oh, yeah. To add to that, to look like as an exhibit in court.
Right, and he's saying basically everything I write now, I look at it as an exhibit in court. And when you're in custody litigation, that's exactly how you should think of it. Because she's thinking the same thing. If this isn't something you would text to the judge or read in front of the judge, you probably should not be sending it. If you're not getting anywhere with her, and if you have an attorney, hey, maybe your attorney can contact her attorney. But as a pro se litigant, you have to be extremely careful what you write down. Remember, you guys are men, right? Emotions do tend to lose cases for men. Emotions tend to win cases for women. You get emotional in a text message and it comes across threatening, well, then what? She's already saying you're abusive and controlling. Then you have this text message. That voices frustration. But it's a losing battle. Don't engage. Don't engage. So the question is, could this be like the death knell of one's case? Maybe. It depends on what you say. So, I mean, there's been some threats that were made over text messages. Now, that's enough to warrant criminal charges as well. So, but it depends. I think the family courts have seen emotions, okay? But my fear is that they're harder on the men when they show emotions than they are on the women, okay? Yeah. Okay, so the comment was, if I'm not likely to engage, then when I go and pick up my child, then there's issues there. I'll leave, I'll send a text message detailing out everything, and then sometimes she texts back and she'll admit it.
Yeah,
okay.
I found that.
Okay. Well, and that goes back to what kind of a state are you in? Are you in a one-party state or are you in a two-party state? If you're in a one-party state, the whole interaction, the whole exchange should be recorded anyway, where you don't have to go back in detail. Let me summarize what just happened, because you've already got it. So if she doesn't know that you recorded that, and you get to court, and you bring up, well, it was Friday at 6 o'clock, I went to her house, knocked on the door, she told me to F off, my child was sitting there, and his stuff wasn't ready. She said that my child didn't want to go. My child started crying and said, Daddy, I want to go with you. All right, and then her version is, he came up, I didn't knock, he just kicked the door, and the door flung open, and my child started crying, okay? You just play the recording. But if you're in a two-party state, you might have to document through text messages. He's saying if there's an extended period of time, such as birthday parties, you may not record all of that. The answer is yes, you do.
Oh, really?
Yes. Now, there's recordings that will run consecutively for up to 150 hours, so the answer is yes. Yes, you do. So, I mean, we have clients that they're bringing recordings, they're 4 hours long, and they're like, if you get to hour like 3:57, there's some great information in there. And we got it right here. So the answer is yes, you let it run. Yeah, so the question is there a trend for the states to switch from one party to two party? I can't really see a trend in that. What I do see a trend in is even in the one-party states, the courthouses are starting to enact administrative rules that there's no recording in the courthouses and there's no recording in the courtrooms. A lot of information, you can get good information, you can get good recordings at the courthouse. Unfortunately, some of the we have less than honorable judges, some of them, and some of the court transcripts have been known to be altered. So it puts you in a position then where you have to bring your own court reporter. But I'm digressing. But no, I don't see a pattern as of now. I see the courts themselves modifying the rules. Mm-hmm. Okay, so he's saying, what if mom's in a two-party state and dad's in a one-party state? Right? It depends where you're in court. If you're in court in a one-party state, then you can admit it. Now, if you're in court in a two-party state, then you can't. Okay, it just depends on the laws of the state you're in. So one-party state is you can record a conversation so long as one party knows it's being recorded. So if I want to record you And I don't have to tell you, but I can legally record it and use it in court because one person to the conversation at least knows it's being recorded. In two-party states, both parties have to know it's being recorded. So if you're in Florida, it's a two-party state, when you call someone, you have to tell them this call is being recorded. Okay? And then, of course, you know, everything diffuses, which might be good in some situations. So that's the difference. Yeah.
Just to piggyback on your person.
So Jeremy is correct. He's saying make sure that the recording is on you, on your person, okay? So if you and I are having a conversation, I'm there for the conversation. I can't put a recorder in a teddy bear and send it off to mom's house, okay? Because I'm not there. Then it's 0-0. Nobody knows it's being recorded, okay? So the one party means that it's your actual conversation. So yeah, don't send recorders and backpacks and teddy bears because you can subject yourself to criminal liability, right? Courtroom presence, dress for success, right? I mean, dress like the person that you want the judge to see you are. Don't walk in there with your shirt hanging out. In fact, in Montgomery County, you can't have your shirt hung out. They wouldn't let you in the courtroom. So dress like you're going to court. Dress professionally. If you have a suit jacket, put it on. You don't have to buy a suit if you have khakis, a button-up, something. But dress like you're going to church. Dress up. Show respect. Even though no one may be showing you respect, show respect. Okay? You are there. The judge might be rude, the attorneys might be rude, the bailiffs might be rude. You do not be rude. You show respect, okay? Don't let her lawyer rattle you. That's their job. That's their job to rattle you, okay? I can't tell you how many women have gotten so mad at me. I swear sometimes they're just going to come over the podium. And I'll take one for the team, right? But sometimes they just want to come over the podium and they get so mad. That's my job. That's my job. It's their job to do that to you. But the difference is what? You guys are men. When you guys get angry, like, oh, well, he better take an anger class, right? So you have an anger problem. No, I'm frustrated, right? Whereas if a woman gets upset, okay, so, well, what mother wouldn't be upset? She's trying to take my children from me, okay? So don't let her lawyer rattle you. If they disrespect you, just yes, sir, no, sir. Yes, ma'am, no, ma'am, okay? Again, go back to answer only the questions. Just the questions. So, and this happens when we get nervous. Again, we have this desire to explain ourselves anyway. And then when you get nervous, sometimes you tend to maybe answer the questions too quickly or give too much information. That's when you get in trouble. Okay? So if the question is, you know, are you dating someone? If you are, the answer is yes. Yeah, I mean, I'm dating somebody. We've been dating for 3 months. I mean, she works nights, I work days, so she's not really even there when I have a child overnight anyway. And I mean, she has 2 kids. Only one's been removed by CPS. So I mean, yeah, everything's great. Okay, now I just exaggerated there a little bit, but you could say something, say, you know, I mean, she got full custody in her divorce. I mean, you know, and I mean, he made allegations and they were found to be false. But when people get nervous, they tend to rattle and rattle and rattle. Don't do that. The question was, do you have a girlfriend? The answer is yes or no. Okay? Don't volunteer information. Yeah. All right. So the question. Okay. Yeah. Oh, okay. So what she said was, don't be sarcastic. It doesn't come across well in court. It doesn't come across well in the transcript. Right. So if the attorney comes up, I had this happen in court. Ask my client, you ever had an affair on your wife? And he's like, I know you've had 3. Want me to name them? Okay. The judge was like, that's enough. The judge got upset. Okay. Don't do that. You are on trial. This other attorney is not. You're going to anger the judge if you do that, okay? Ask, you know, if you, so you want to, you know, how many physical altercations have you been in? I'm about to be in one in about 2 seconds, okay? Don't do that, even if you want to. You don't do that. You don't say that. So keep sarcasm at a minimum. Remember, unfortunately, you're not in control of this proceeding. You are on trial, okay? So yes, please keep the sarcasm to a minimum. So the question was, do the rules of civil procedure allow you to confer with counsel before answering questions? Okay? If the question is, let's say if the question is, you know, do you beat your wife? If my client says, can I confer with my counsel first? I'm going to be mad. Okay? Because the answer is clearly a resounding no. Okay? So, but if it's something, now your attorney should also step in. For instance, if there's a criminal proceeding that's pending, and they ask a question about the criminal proceeding, you can stand up and say, Your Honor, before my client answers the question or pleads the fifth, I'd like a minute with them, please. Now, most judges will allow you to do that. So again, this is for pro se litigants, but I would also make sure that you have a dialogue with your attorney. If it's a question of legal significance or something that could greatly affect the outcome of your case, or if you don't understand the question, you can ask, can I confer with my counsel? But usually your attorney is going to get up and be the one to say, Judge, can I have a minute? Okay? But, like again, if they're simple questions, don't ask to confer with counsel. Right? All right. And as a pro se litigant, if you don't understand the question, say, I don't understand the question, right? Because once you answer the question, the court's going to assume you understood the question for the most part. Okay? So if you don't understand the question, say, I'm sorry, can you rephrase that? I don't understand what you're asking me. Okay? Every answer should reflect the best interest of your child. Okay? So, well, Mr. Smith, you say you don't have enough money. Why do you only have one job? Because I'm a father. I'm not going to work around the clock because I want to be there when I pick my child up from school. I want to be able to do homework with my child, put my child into bed. Okay? Say, well, because, I like football. Football season's coming up. Nobody wants to work around the clock for football season. So when you're asked about that, remember where you are. You're in family court. So when you're asked questions, the questions are going to reasonably somehow relate or be twisted to relate to your ability to care for your child. Okay? So remember where you are. This comes up a lot with child support. You don't want to pay child support, do you? Well, does anybody here want to pay child support? Okay, nobody wants to pay child support. You want to support your child. So you don't want to pay child support, do you? Sir, that's not what this is about. I want to take care of my child. Now, I don't think anybody should concede, I want to pay exactly what the court tells me I have to pay. It is what it is. But remember where you are. If you disagree with child support calculations, okay, it's not going to change the law to have an argument with the attorney right then and there. I don't have a problem supporting my child. In fact, I have been supporting my child. I got all these bank statements, I got all these receipts. It's not about that. Just remember where you are when you're answering these questions, okay? Now, even as a pro se litigant, you have to follow the rules of civil procedure. You have to follow the rules of evidence, okay? Just because you're pro se doesn't mean you get a pass on the hearsay rules. Hearsay rules apply. I can't tell you how many times pro se litigants come in and they have their folder and they're like, Judge, can I give these to you? There's 10 affidavits in here. No, you don't get a pass because you're a pro se litigant. Rules of civil procedure still apply. Rules of evidence still apply. Okay? You're held to the same standard as an attorney, even though it's nearly impossible, bless these pro se litigants, bless their hearts, for them to perform at the same standard as attorneys, but you're held to the same standard. Now, last, make sure your address is updated. Now, when there's divorces, there's relocations, you move around. If you don't keep your address updated with the court, you're not going to be, you're not going to be aware of filings. You're not going to be aware of court dates, and you're going to miss court dates. And I didn't update my address with the court is not enough to have like a default set aside. You're supposed to keep your address updated, so make sure you do that. So if the divorce is filed and you're still living in the marital residence, but you leave, you have to go to the court, give them a change of address, and say, this is my new address. Now, if you do that, and they still send to the old address, well, then you've got something to say, hey, look, I missed this court date, and it wasn't my fault. The court sent to my old address, and I came in, and I gave you my new address. So make sure that your address is updated, because when you're a pro se litigant, you can't rely on an attorney to get these pleadings to you. They will be mailed. They snail mail everything to you. Okay? Now, some states will do email addresses, but most states, my understanding, are still on the snail mail. Okay? Okay, now, let's say you go to court and you make your case and you don't like the result that you get. There's different levels of appeals. You can do an appeal, in almost every state that I'm aware of, at the trial court level, okay? So in Alabama, they're called like a Rule 59, motion to alter, amend, or vacate, and a lot of these are precursors to going to the Court of Appeals. So what you do here is you lay out your reasoning for the appeal. Okay? So in this case, this was an unmarried father. So the best interest standard applies. And there's different standards that apply as well. If it's the initial determination. The best interest standard applies. So in theory, you're both on equal footing. Court doesn't give one more deference over the other. We all know in application that really doesn't happen, but that's the theory behind the best interest standard. You go in there on equal footing. Now, in some states, Alabama is one, after a decision is made, mom gets custody, dad is, has joint legal custody, which means nothing, we'll get there, but, mom has all decision making. Now, once that is in place, if dad wants to go back and change that, a higher standard is applied to say, no, you're not on equal footing anymore. Now the court's going to presume, really, that the child should stay with mom, and you have to now show that it would be detrimental for the child to stay in mom's care to switch it here or to switch it here, okay? So it's important that you make your record and you do a good job at your initial determination. So in this appeal here, so we litigate this case, we do a phenomenal job. This is a baby now, so we know we have our work cut out for us because we're asking for shared custody of an infant. So we get to the trial court. And again, you look at the best interest standard. We don't have schools to rely on. This is an infant. You can't really claim alienation other than mom's behaviors, but the child's not rejecting dad yet, nothing like that, because it's a baby. So we bring in nephew who testified, yeah, he pretty much raised me. He acted like my dad. Brought in friends. We brought in everybody to meet all the standards that we could possibly meet. So mom comes in, and mom's young, 24 years old. This is baby number 2, and never talks about the child. We know that she had a difficult pregnancy. We know she was on magnesium. We know that she graduated with a BSN in nursing, and we know that she's going on to nurse practitioner school, because oh my gosh, and I mean they accepted me in nurse practitioner school, and I was really young, so I was like, oh my gosh, I was really flattered. And I was almost in it, like deer in the headlights, like watching her testify. Nothing about the child. I don't even know who bathed the child. The only reason I knew that she was this child's mother is because she gave birth to her. There was nothing. You go down the best interest standards, she ignored all of them. We hit every one we could. She ignored every single one. So what we did, we went back and filed the appeal at the trial court level, attacking sort of the best interest standard, but we really threw the constitutional stuff in, okay? It's important that you guys litigate constitutional issues. You have a constitutional right to parent your children. What does it mean when you parent your child? It's really the decision making, right? That's what, with my kids, that's what, separates me from her, is I make decisions for these children. I decide where they go to school. I decide when they go to church. I decide what they eat. I decide medical care. That's what makes me a parent, is decision making, custody, and control. That's what makes me a parent. So that is the definition of being able to parent your child, right? And the Supreme Court has recognized it. Okay? So we go through here, we put in here, the Supreme Court has consistently upheld parental rights as a fundamental constitutional right. We put everything in there. And basically what this judge did is the judge said, well, you have joint legal custody. Mom's the primary physical custodian. Well, under Alabama law, joint legal custody means that the dad has access to medical records, he has access to school records, but there's no decision-making authority. What parenting goes on when you're a visitor? There's no decision-making. Well, but he gets to decide what he feeds the child on his weekends. I'm pretty sure that's not what the Supreme Court meant when they deemed the right to parent your child, a fundamental constitutional right, to decide what they eat when it's your weekend. That aside. So what we've done, and I'm not going to read everything to you, is we laid out the constitutional basis behind the fact that this father was deprived a constitutional right for no reason. It doesn't even meet the best interest standard. Okay? So, but I want to show you, we had a hearing on this, and I'm talking to mom. So I say, I haven't heard you give any testimony that would say or suggest that you don't think that he's a fit and capable dad of taking care of his daughter. Is that true? She goes, well, that's your opinion. So I said, no, do you think he's a fit parent? Do you think he's a fit father? Well, I never said he wasn't. I just didn't feel that our daughter was ready. And that's exactly what I said, is it not? She's a little bit sarcastic. And I said, no. She said, you said she wakes up at night. I did. And there's numerous messages where I say I don't feel that she's ready for overnight visits. And that was just one of the reasons that when he kept asking me specifically, why? Because the child wakes up at night. That's it. Child wakes up at night. Okay? I said, so you have no evidence that he's unable to care for a 10-month-old little girl, his daughter, do you? Correct. But I have no evidence that he can either. Right? So now we have to prove a negative, I guess. Right? But the reason he's had such a lack of contact with his daughter is because you have greatly restricted his contact. She said, but there's been numerous times that he was supposed to pick her up and he didn't. Numerous. So if he hadn't used those times, and I don't control his schedule. And I said, can you point out, now they said that every communication is in text messages. Can you point out where in these messages, since this was really your main mode of communication, she cut me off. She says, there's been numerous times I've told him he could. Okay? So can you point out where you offered times where he just, quote unquote, didn't show up? She said, okay. One of the last visits, he told me he had a meeting at 10. Okay? She said, he had a meeting that morning. I don't want you to say that I said something incorrectly. He had a meeting that morning. He texted me the night before that he would be there to pick her up at 10. Instead, his mother came. Said she'd been at the dentist. When it got time to have her back, his mom came back. So that was her saying he didn't show up because he sent somebody else because he had a meeting at 10. Okay? So why do I bring this up? It seems petty. Well, it is petty. Most stuff in family court is very petty. But she made the comment, there's numerous times I told him to get his daughter, he just didn't show up. You can't let that slide. Okay? Well, you testified earlier that everything is done through the text messages. Here, show me in this text message where he just didn't show up. All she could come up with was, well, he told me he had a meeting at 10 and his mom came to get her. So, sounds petty. But what if you left that alone? What if all the judge heard was, there's been several times I told him he can get his daughter and he didn't show up? All right? That could be huge. Judge could think, well, I mean, maybe this guy isn't as serious as he thinks. So when something goes against you, you have to challenge it. Okay? We challenge that there, and it's absurd. It's ridiculous. Okay. I'm not going to read all this stuff to you. Okay, so she said, asking her about, they both worked from home. Okay? Well, he worked from home. He made a 6-figure salary, had a home-based business, and she went to school online. And so I asked her, well, let me ask you, if he's able to work from home, you work from home, isn't it fair to either one of you or your daughter that is it fair that one parent have vast majority of the time where both parents are available to provide care? Okay? She says, I think both parents should be involved, but I think that she should have a stable home environment. This is what we were talking about yesterday, this stability. It's not stable for her to go back and forth. But yet there's no definition of stability, right? But it sounds good. So you have to challenge that. She said, fast forward to when she's older. How is there any stability when you get out of school and you don't even know whose vehicle you're going to get into today because you're not sure if it's mom's week, dad's week, or whoever else, grandmother, other grandmother, aunt, nephew, okay? So what is she doing? Just smoke and mirrors, just clouding everything up, okay? So I said, let me ask you, you look at education, right? Because we asked for education. And let me tell you this too. If you're in a jurisdiction where you can ask the judge for decision making, you want to sink your teeth in education, I'll tell you why. So we asked for education, and I said, can you tie life experiences into that? You're 24 years old, correct? Okay. Now, my client was substantially older. She's 24 years old, never not lived with her parents. She says, correct. You live at home with your parents, correct. You have 2 children from 2 different fathers, correct. You've never been married, correct. Your dad, on the other hand, is a high-level supervisor in a multi-million-dollar corporation, correct. Supervises employees, has gone to college, did not obtain a degree, but he has significant education. He's done very well for himself. And she came back, and her response was, "I just think I'm better. I have a BSN. 24 years old, never lived outside her mom's house." So you have to confront these things, attack these things. Now, this is why I like education. Because if you're in a 50-50 split, okay, most jurisdictions have a rule where you can move a certain distance away from you don't have to go back and modify everything. So if you have education, you control the school district. Mom can move where she wants. Like in Alabama, a mom under a 50-50 split can move, or a dad, can move 50 miles away without having to get court approval. But what does that do to the school district? It can move your child 50 miles away What does that do if you have week on, week off? It's extremely difficult to take this child back and forth to school. If you can maintain control over education, mom can move where she wants, doesn't matter. You chose the school district. You can say, okay, that's cool. You can move 50 miles away, but the child's going to stay in this school district right here. Okay? It keeps them from moving around. The two big ones are medical and education. Those are the two biggest decision makers. I tend to like education because most mothers are going to get medical care if their children needs it. I had one case where a mom didn't believe in medical care in 12 years. So generally, you see if you want to try to control education. Anyway, all right, so we're talking to the judge, and I tell the judge, Judge, we know from our testimony that she indeed did give birth to the child. That's the only testimony she gave. There was no evidence regarding her ability to care for this child, her bond to this child. There was nothing. We heard a lot about her going to school, heard a lot about the birth of the child. We heard a lot about her experience with magnesium. We heard a lot about that. But we didn't hear anything about how it's in the best interest of this child to remain in her sole physical care. She didn't meet the best interest standard. We go on. We say, and also, Judge, it's a constitutional right to parent your child. For my client to be stripped of that, of the right to parent his child, care and custody, make decisions, that his overall fitness should be shown that he is not fit before he is stripped of that. Parental rights are all of these things, these decisions, the care and custody. The court said, I think that's a mischaracterization, Miss Isaac, with all due respect. I didn't strip him of anything. I found him to be very, very concerned about his daughter. The week on, week off very seldom works. There are a few occasions where it does work, but for the most part, and that's the unfortunate thing about divorce and custody, one parent has less time with the child when both parents are fit. All right. Is there anything we could have done with this judge? Absent bringing in the school children she sells drugs to and pictures of her snorting cocaine. Is there anything we could have done to get 50-50 in this case? We asked for it. We made a case for it. He did a wonderful presentation. This judge does not believe in shared parenting. And we're dealing with a baby. We're dealing with a baby. We should have won. Should have won this case. So the frustrating thing is you can do everything right, make no mistakes, have the better case. But if you don't have a judge who believes in 50-50, it may not matter. Now, I don't say this to deter you. I want you to still put forth a very good case. But I want you to understand, we all know, that's why we're the Father's Rights Movement, that this still exists. This is not enough for a recusal. And this, by the way, is we're in the stage where we're at the appeal at the trial court level. Okay? But it was perplexing. This mother said nothing about this child during the hearing, literally nothing. In fact, I think we got more time going after a split custody. I think we did. In fact, the judge actually, told us that he, and it was disheartening because the judge was proud of his decision. And didn't understand why I wasn't happy with the decision. He said, he gets every other, like Wednesday night through Monday morning. That never got that much time with a baby before. That's the best order he ever gave for a child. He really couldn't understand why I wasn't happy with that. Just, so, but that's part of the battle that we're in, right? We're part of this battle where we're trying to change status quo. And the younger judges that are coming on, the pendulum is swinging. Okay, I mean, we rarely get a straight up, every other weekend, full child support. We rarely get that anymore. Okay? Now, we're not getting 50-50s all the time, but we are getting 10 days a month, 12 days a month, which is a heck of a lot better than 4 days a month. Okay, so the pendulum is swinging. So do your jobs. Make a case. Argue these constitutional stuff. Do everything that you're supposed to be doing, okay? Because we're making change. Now, with this case here, we did everything right. We didn't get 50-50, but we got a heck of a lot more than we would have gotten had we not made the same case. Okay? All right. Okay, here's some pitfalls. We got about 5 minutes left. So some pitfalls. Don't text when you're angry, okay? We kind of already hit on that. Don't text when you're angry. Record if your state allows. You don't want to avoid the he said, she said. At all costs, you guys, avoid the he said, she said, because invariably you lose on a he said, she said, especially with domestic violence. Family wizard apps or different types of apps where you communicate and everything is banked for court. All right, so all your communications are in there. Don't put yourself on child support. Guys, so many dads think, I did the right thing, I went down and put myself on child support. In most states, an order of support is also an order of custody. Okay? There's no visitation or custodial periods awarded, so you go down and think you're doing the right thing, you sign up, start paying for child support, and guess what? You just gave her custody to and you just didn't know it. So if you're looking for time with your child, the child support court is not the right avenue to do that. Okay? So don't go put yourself on child support. Now you want to give her some support. Even if she's not letting you see your child, still give support. Send checks. All right? Now she may not cash your checks. You might have to go maybe to her bank, deposit in her account. Now, in this case I just told you about, she asked for back child support. She didn't get it because we offered, gave her checks. She wouldn't cash them. So the judge says, you're not getting back child support. He tried to give it to you. You wouldn't take it from him. But make the attempt, okay? Don't wait until the last day to ask for a lawyer. So if it's the day that you have court, you walk in there and you're like, hey, judge, you're like, I don't have a lawyer. There's no right to a lawyer in family court. It's not a criminal proceeding. The judges don't, or the courts don't have to give you a lawyer. So if you go in there and say, well, I'll just tell the judge I don't have a lawyer, I can't proceed today, the odds are you might still proceed. So don't wait till the last day to try to get counsel or to walk in when it's a hearing date and ask the judge to give you a lawyer, because they don't have to do that. Don't wait too long to seek court intervention. We already went over that. If you're not seeing your child, but you wait a year before you file something with the court, that's a whole year. You lost a whole year where status quo has sort of been established that this child lives with a mom. So don't wait too long to get court intervention if you have to. Leaving the house, if you have to leave the house, make sure if you can't keep that relationship intact with your child, seek court intervention, okay? But again, if there's domestic violence, leave the house. And don't not report it if you're the victim. Don't be afraid, don't be ashamed, don't be embarrassed. Report it. What would happen to you if you treated her the way she just treated you, right? Report it. Report it. Had a case where my client came home from a trip. He had his recorders on. He walked in. The first thing she did was open the door, curse him like a dog, and you can hear her slapping him, okay? He called the police. Police got there. You can tell the police were like, well, yeah. He said he had a recording. She went to jail, all right? So report domestic violence, you guys. Don't be ashamed. Well, there's this Troxel v. Granville, okay, and it's in the slides. The Troxel case is actually a case that litigated grandparents' rights. But the Troxel case was wonderful because in the analysis it goes through the history of parental rights and it identifies the right to parent your child as a fundamental constitutional right. So those of us who are attorneys, we know that when something is a fundamental constitutional right, it evokes this sort of strict scrutiny analysis, okay? So this analysis is applied to constitutional fundamental rights except for family court because they seem to have a pass on that. But in the PowerPoint slide, the case law is cited in that trial court brief. Okay, so the question was about Kramer and Santusky, and then there's also the Stanley case, and I love the Stanley case, but Troxel was a grandparent right case. I think Sandusky and what did I just say? In the Stanley case, those deal more with actual parental rights as a main issue versus a peripheral issue, if that makes sense. But yeah, but they're cited in there. So in this case, we had binders full of text messages because all they did was communicate via text message. We had tabs every time he asked to see the child. We had tabs when she wouldn't respond. We had tabs for, the purple tabs were for every time he offered child support. The pink tabs for every time he asked for contact. So we had it broken down. So what we did is, and we admitted all of them as evidence, right? And we just explained to the court, and then what we did is when she was testifying, if she said, well, I've never said that, I would flip to it, have her read it, go over it, put it on the record, but we did admit everything, but everything was very well organized so the judge could flip through if he so desired. But nonetheless, it was part of the record. So the comment was basically, so there was no issue with the judge saying, look, I'm not going to read that because you just dropped 500 pages. And judges hate that, by the way. Well, if you come in there and you say, you just do a document dump, here, judge, here's proof of everything I just said, and dump it. They're not going to read through all of that. So have it organized. And Jeff makes a very good point. And that goes back to when we said, make this as easy for the judge as you can. Okay? That goes back to that. So you say, judge, here's a stack of text messages. I have it broke down. Now, here they are in chronological order. This stack just deals with schooling issues. This stack just deals with contact. This stack deals with this. So make sure you make your record, but you want to break it down and make it as easy for the judge as you can. Okay. Okay. How do you testify pro se in a hearing?
Yes.
Okay. Well, you can make legal arguments. Okay. Judge might say, Mr. Smith, if you're the defendant. She might get up there. They might call you to testify, but you'll also get your turn. Judge will ask you, your arguments are testimony because you are yourself. If I get up and I argue for you, that's an argument. That's not testimony. I'm not you. You'll get sworn in, even as a pro se litigant, and your argument can be taken as testimony. Yeah.
So it's more so.
Well, it is a statement, but you're a party. You're not an attorney. So, but you're sworn in and you can give testimony. Yeah. So what Jeff is saying is that you can ask the court, you just testify in a narrative, which is basically you're not being asked any questions. You're just sort of telling the judge what it wants to hear. But if you're pro se and she gets up on the stand and she talks about contact, she talks about education, she talks about child support, you can say, all right, judge, as it pertains to the issue of child support, okay? And then you can give your narrative as it pertains to that. Make it as organized as possible, because what the judges hate with pro se litigants is some of the stuff you say may not be relevant, you might jump around, you don't want things to get personal. It's about presenting to the court and refuting what's already been given to the court, okay? Make sure it's very organized and very methodical. No, you can talk to your own witnesses. In fact, if someone discloses a witness list to me for the other side, I can call their witnesses. Now, there's a difference between witness tampering and case preparation. Now, you don't want to call them and say, look, something bad might happen if you testify. You're not intimidating witnesses. You're not tampering with witnesses. But you can speak to them, and you can ask them to testify on your behalf. You can't tell them what to say. You can discuss what's going to be said, but you can't tell them what to say, and of course you don't want to engage in any sort of acts of intimidation. You don't want to say anything that might intimidate any sort of witness. But no, there's nothing wrong with you contacting witnesses. You can do that. Okay? All right. Thank you.